This section is designed to cover the law relating to criminal justice, and in particular to look at the law as it sets out the sentences available to courts. As far as social workers are concerned, this law is supplemented by the National Objectives and Standards for Criminal Justice Social Work Services. These are too extensive to cover in this section, but links to them are provided. This introduction looks at the system of public prosecution, alternatives to prosecution, the criminal court system, and procedure in the criminal courts. First, though, an overview of the use made of the various penalties available to the courts. As the graph shows, the main penalty is a fine, followed by a community sentence, admonishing the offender, and finally custodial sentences, either in prison or in a young offenders institution. All of these are dealt with in more detail in the reading, but one obvious change over time has been the increased use of custody and the change in the balance of non-custodial sentences. Scotland has for a long time had a system of public prosecution, and decisions about whether to prosecute and which court to prosecute in are taken by the state, except in a very small number of cases where private prosecutions are allowed. There were only 2 of these in the 20th century. The organisation which oversees this is the Crown Office Procurator Fiscal Service. This is headed by the Lord Advocate and Solicitor General and employs the Procurators Fiscal, who undertake most of the prosecutions in Scotland and take most of the decisions in prosecution, though in more serious cases advice may need to be sought from one of the Advocate's depute employed by the Crown Office Procurator Fiscal Service. Instead of prosecution, there is a number of alternatives. First, to take no further action, for example if there is not enough evidence or if it is not in the public interest to prosecute. Secondly, a fiscal warning. Literally that. There must be enough evidence to prosecute and the offence should not be so trivial that it should be ignored. A fiscal fine. This gives the offender the opportunity to pay a specified fine. If the offer is accepted and the fine is paid, no conviction will be recorded. The offender can be offered the opportunity to pay compensation to the victim. A conditional offer of a fixed penalty can be made, for example for a motoring offence where, if you pay the fine, there is no further action. And finally, it's possible for there to be diversion into a programme offered by social work or another agency, but what is available by way of diversion will vary between different areas across the country. The lowest court in the criminal court system is the Justice of the Peace Court. This is based mainly in local authority areas, and the judges in it are not legally qualified, though they do have to undertake training. Summary procedure is used here, that is, there is no jury, but the decision in guilt is made by the judge. Moving up, we come to the summary sheriff. These are sheriffs, as we have seen in looking at the civil court system, who have limited powers. They can deal with cases heard under summary criminal procedure. This procedure also applies in the case of a sheriff sitting in a summary court. The sheriff sitting in a solemn court hears cases which are being dealt with through solemn procedure, that is, where there is a jury of 15. These, it goes without saying, will be more serious than the cases in the summary court. The final trial court is the High Court of Justiciary, which is a solemn court which hears serious cases. It is the only court which can, for example, hear prosecutions for murder and rape. The judges are the same as those who sit in the Court of Session, but unlike that court, the High Court sits all over Scotland. Appeals from the summary courts go first to the Sheriff Appeal Court, and then possibly on to the High Court sitting as a court of appeal. Appeals from solemn courts go straight to the High Court sitting as a court of appeal. Summary charges are set out in a complaint, to which will be attached a number of other documents, for example a list of any previous convictions. Summary procedure starts with a pleading diet. This can involve an appearance from custody, but can also involve an appearance where the accused has been at liberty pending trial. At this diet, the accused has to plead guilty or not guilty. If guilty, there is a possibility that they will be sentenced there and then, though the court may defer, that is, postpone, sentencing, for example pending receipt of a criminal justice social work report. If the plea is not guilty, the accused may then be remanded in custody or released, either on bail or, most likely, without it. The next stage is an intermediate diet, designed to check on whether the accused is still pleading not guilty. if both sides are ready to go to trial on the date fixed for the trial diet, and if any uncontroversial evidence has been agreed. If the accused is still pleading not guilty, the case then moves on to the trial diet. At the trial, the verdicts possible are guilty, not guilty, and not proven. Following a guilty verdict, the offender may be sentenced immediately, or sentence may be deferred. The deferment may be to allow for the production of a report, and in some cases, for example before imposing a first custodial sentence or imposing a community payback order, a criminal justice social work report must be obtained. Sometimes the court may use the deferment to allow the offender to show that they can stay out of trouble or to pay back money which was stolen. When the offender returns to court, they will be sentenced. Solemn procedure starts off with an appearance before the sheriff, regardless of which court is going to try the case. This appearance is on petition, a preliminary form of the charge, and the accused can either be committed for further examination, after which they will be brought back in front of the sheriff, or committed for trial. After this, they may be released or kept in custody. The next hearing is a preliminary diet with similar functions to the intermediate diet and summary procedure, and then, if the accused still pleads not guilty, the trial diet. The range of verdicts is the same as for summary courts, and decisions will need to be made about sentence. There is a mandatory life sentence for murder, but the court still has to determine how long the offender must serve before they are eligible to be considered for release on parole. I should also add that after appearance on petition, a final form of charge is served on the accused in the form of an indictment. This slide shows some rough statistics based on the court disposal figures produced by the Crown Office Procurator Fiscal Service. You will see two things. First, how few people go to trial in lower courts and how this changes as the courts deal with more serious crimes and offences. And it's maybe worth also saying that there is no real legal difference between crimes and offences. The second thing that you will notice is how much of the criminal court business actually takes place without a jury. This final slide shows the sentencing powers of the various courts in terms of fines and custodial sentences. Other sentences are of course available, for example community payback orders. In addition, where an offence is created by an Act of Parliament, the Act will often specify the maximum penalties for that offence, and these are likely to be less than the general maxima which are set out on this slide.